Assalamualaikum warahmatullahi wabarakatuh. My name is Nafisya binti Mohamad Arshad. My matrix number 117042. Okay, today I would like to present to you about my poster FYP of my research article, which is the title is An Analysis on the Dispute Rights of Women in Matrimonial Property Claim. Okay, first I want to define the meaning of matrimonial property. Okay. Matrimonial property is property acquired during the subsistence of marriage as husband and wife, which is as a result of their joint effort. It is a recognized custom which is practiced from time immemorial. Since the principle of matrimonial property is not contrary to the requirement of Islamic Syariah, the provision of matrimonial property is accepted as part as Islamic law in Malaysia. According to the Section 2(1) of Islamic Family Law Act 1984, matrimonial property means property jointly acquired by husband and wife during the subsistence of marriage in accordance with the condition stipulated by Hukum Syara. This means that any property, whether movable or immovable, acquired by the husband and wife during the period of marriage is a matrimonial property that creates their joint rights in the property. Okay, we move to the objective. So, objective of this research is first to identify the parties beside of husband and wife who can claim matrimonial property after death. Okay, second, to analyze the right of a housewife to claim matrimonial property, especially the full-time housewife that doesn't work. Third, to identify the status of the EPF money calculated as a matrimonial property. Okay, next we move to the methodology of this research. Okay, this type of study is a qualitative study. Qualitative research is the study of finding and providing evidence and non-numerical observation, although there is evidence that refers to statistics. Okay, data correction methods are used in obtaining the data of the study, such as documentation method. This method obtains data through reading from documents related to research question. The sources of the study can be in form of primary or secondary sources of study by local or foreign scholars. The primary source of documentation refer to the books of Malaysia Syariah, the Federal Constitution, Act, enactment, and cases that have been reported in journal and journal article. While the secondary documentation sources refer to such as books, newspaper, journal, paper, and website. Okay, next we move to finding and discussion. The first point is the parties who can claim matrimonial property beside of husband and wife. Okay, surely it can be said that the person entitled to claim the property after death is the husband and wife. However, the heirs of the spouse, such as children, the parents of the deceased, also may claim the property if the parties in the marriage do not submit any claims. Okay, based on the view that the right to the property are indeed subject right in itself, whether the husband or the wife who can claim either because of divorce or the husband wishes to polygamy. The next of kin of the deceased is also entitled to claim the property as a result of the disease. Okay, unless there is evidence to indicate that there has been a hibah or relinquished the right to the property or by any party. Okay, the next point is the right of a housewife to claim matrimonial property. Okay, a wife, while conducting her work as full-time housewife, can claim for matrimonial property as it is considered as indirect contribution. Okay, in terms of indirect contribution, especially for non-working wife, there are several distribution rates such as 1/2, 1/3, 1/4, and 2/3 depending on the point of indirect contribution that given. Okay, typically, women still play an important role to family institution. This is because they play a role in educating and maintaining the harmony of a household. Okay, according to the Section 58 of the Islamic Family Law Act 1984, the state also emphasized the importance of role and contribution of this non-working wife to be evaluated and observed by the court before any distribution order is issued. Okay, the next point is EPF money as a matrimonial property. EPF saving partnership is not an displayed partnership in the form of property, even though there is sharing of effort and energy, and the contribution of a spouse or husband to his spouse inside or outside the house is not of the same type of work done by spouse. Therefore, EPF savings are not a form of matrimonial property, but a must distribute inheritance to those who are entitled to receive it by Sharia law. Okay, according to the Section 51 of the EPF Act 1991, surviving EPF savings are the absolute right of contributors to their welfare on all days, which cannot be transferred to other parties. And then, EPF money is not regarded as matrimonial property because it is a compulsory scheme for all wage earners in order to provide them with some financial protection for retirement. Then we move to the conclusion. So, as the conclusion, both civil and Islamic law recognize an individual's right to own property regardless of their status, married or non-married, in terms of possession of the property. The matrimonial property is subject to separation, open divorce, or dissolution of marriage, or in case of death, depending on the contribution made by either of the parties to the family well-being, including any contribution made by caring for the home or caring for the family. In deciding the case of matrimonial property, the court usually takes into account the direct or indirect contribution of both parties so that there is no element or persecution against them. Okay. In determining the right to matrimonial property, it's appropriate that the sacrifice and contribution of the parties, either directly or indirectly, are taken into account so that the apportionment of matrimonial property can be done in accordance with the law accepted by the Islamic law and can fulfill the justice emphasized by Islam. So that's all from me. Thank you.